one breath, the former AGF did say the former President Goodluck Jonathan didn't have the power to suspend an elected governor whilst the state of emergency was declared. But now we've seen this judgment which says otherwise. And so one wonders, what's your impression about this judgment, for instance?
Well, first and foremost, the whole idea of the courts is to preserve rule of law. And rule of law is the effective and efficient administration and enforcement of the law in order to bring order to the society. Anytime any branch of government is not conscious of effective administration of the law, it rather brings confusion and anarchy. The job of the courts is to interpret the law, not to make it, not to amend it. And their interpretation should be such that brings order in the society and not chaos and anarchy. You have just pointed out that the position of the court is different from what the AGF has said, from what other people, even the friends of Tinubu that condemned the emergency, the position of the court is even different from them. There was a demonstration of lack of understanding of federalism, of rule of law, and of common sense. Because we are operating a democracy, power to the people. So how can a court rule? And they are putting a constitution that I don't know the paragraph and section they cited, that the power should now be in the president to determine who the leaders of the people are. Let me tell you what rule of law says. According to Professor A.V. Dicey, he was the person that made the first authoritative statement on rule of law. And he said rule of law is the absolute predominance of the regular law as opposed to arbitrary power, and excludes the presence or the existence of arbitrariness or prerogative or wide discretionary powers on the part of government. But you have a Supreme Court that is now giving the president wide discretionary powers, not known to the Constitution, not known to the law. Now, I give you the interpretative power of the Supreme Court. A precedent that the Supreme Court laid by themselves.
Mr. Okonkwo, sorry to interrupt you. When you say that the Supreme Court is giving the president
wide discretionary powers.
Wide discretionary powers.
Yes.
What exactly?
As opposed to the rule of law.
What exactly do you mean? Because the state of emergency, the powers to declare a state of emergency is in our Constitution, isn't it?
Nobody is against that.
Yeah.
Nobody is, nobody is interrogating the judgment based on the fact that the Supreme Court said the president has the right to declare the state of emergency. No. What we ask, the issue here is, does the president have the right to remove elected members in the name of declaration of a state of emergency? And my opinion, respectfully, is no. Because one, it is not reflected in the Constitution. Let me tell you what the Supreme Court said in the case of Atiku versus INEC in the 2023 election, where they told you how to interpret the provisions of the Constitution. And I'm talking about 2023, 19 Nigerian Weekly Law Reports, part 1917 at page 761. The Supreme Court said when you are interpreting the Constitution, you must adopt a polylitic, not a monolithic approach, where you have to take it holistically and harmoniously, one section relating to the other, in order to ensure that you bring out the intention of the legislature when they are drafting the Constitution. In their interpretation of the section 134, subsection 2b, you know what the Supreme Court said? When they gave judgment in favor of President Bola Ahmed Tinubu, saying that you don't need to score 25% in the FCT. They said the reason is that if the drafters of the Constitution meant that he would do that, they would have created another paragraph, paragraph C, to reflect it. Meaning whatever the Constitution did not provide, you as the court cannot impute it in. So if the drafters of the Constitution meant that you will remove elected representatives, they would have included the paragraph in section 305. That paragraph was not there. Now, the Supreme Court said that the Section 305 granted the president to use extraordinary measures
to restore normalcy.
First and foremost, that Section 305 is telling you the conditions that will make it ripe for the president.
That's condition precedence.
Yes, to declare state of emergency. What is the extraordinary measures? It has been explained in Section 45, saying that the president can derogate on some fundamental human rights. If you read Section 45, subsection 3, you will see where they said that the period of emergency is as declared by the president. The president doesn't make laws. It is the National Assembly. He simply implements. Now, even the National Assembly that has the right to make laws during period of emergency, in Section 11, subsection 4, the proviso to it, he said that this power does not include removing elected governor and deputy governor.
But not that the Supreme Court has ruled otherwise.
Yes, first of all,
that one will bow to this one, isn't it what you people say?
No, you see one thing, I agree that by the realism, legal realism school of thought, whatever the court pronounces as the interpretation of the law becomes the law. But this is not a super precedent. Why am I saying that? First of all, they admitted that giving this judgment out of jurisdiction. In law, whatever you say, when you don't have jurisdiction, is a nullity. So the opinion of the Supreme Court should not be disregarded. What I'm saying, they said they don't have jurisdiction, so they just stated their opinion.
It means, what does that mean then?
It means that what they just stated is opinion, but their opinions still matter in legal issues.
So wait, let me just ask you, from a layman's perspective, if they say they don't have jurisdiction, because jurisdiction is key.
Yes, it means that the judgment is a nullity.
But why do they then need to comment?
That is why
they feel
not true. That if I were in their position, I wouldn't have done that. As an apex court, they have the right to just decline the decision and not make any other comment. That is a right given to them, rather than throwing the nation into confusion. Now, what am I saying by this judgment? Can you imagine? What it means is that the president now has the right to suspend 36 governors at the same time. He can declare that there's a state of emergency nationwide and that he will use the military to rule Nigeria for a limited time. What is the limited time? So
is that subject to personal interpretation, limited time?
No.
Or is it just 6 months?
The Constitution said 6 months. So it cannot exceed 6 months at a time, but it can be renewed. So it is, for me, it was delivered per incurium. In other words, not in accordance with the law.
Emergency has been declared. There was no doubt before now that the president could deploy forces or take other steps to restore law and order. What has always been controversy is the extent of the powers. And the Supreme Court made the point that the provision of the Constitution, Section 305, has not set out the extent of the powers that the president can exercise. But in the majority judgment, the Honorable Justice Idris did say that unlike the constitutions of India and Pakistan, Section 305 of the Nigerian Constitution does not expressly confer power on the president to assume or temporarily displace executive or legislative institutions of a state. And his lordship went further to say that this omission, in other words, the omission to empower the president to dissolve democratic structure, is deliberate, and that it reflects Nigeria's constitutional commitment to federalism and the autonomy of state governments. Earlier than that conclusion, the court had also heard that the three tiers of government in Nigeria, the federal government, the state government, and local government, are independent, autonomous tiers, and that none is superior to the other. In other words, the Supreme Court was simply following its earlier decisions to the effect that governors of states cannot suspend or remove democratically elected chairmen and councillors. In like manner, the Supreme Court has now reiterated its position that elected structures, elected public officers cannot be removed, cannot be dissolved or suspended or displaced except in accordance with the provisions of the Constitution. So I would therefore urge Nigerians to study the judgments very well. In fact, for the avoidance of doubt, in what has been regarded as a minority judgment, the Honorable Justice Obande Ogunya did not in any way prevaricate. You know, his lordship made the point that there is no provision of the Constitution that allows or that empowers the president to remove elected public officers. What the Supreme Court did not do, and I think this was deliberate, was to pronounce on the merit or otherwise of the imposition of emergency rule in Rivers State. It might be said that it has become academic because the governor has since resumed his duties. I mean, I'm talking of Governor Fubara. But the other confusing part of the judgment is where the Supreme Court challenged the local standard of the plaintiffs, that is the 11 attorneys general that filed the case. I'm saying this is worrisome because in the case of Attorney General of the Federation and Attorney General of Abia State and 35 states, decided in July last year, the local standard of the Attorney General of the Federation was challenged. But the Supreme Court said no, that the Attorney General has the local standard to file the action on behalf of the 774 local government. So if that was so, I was of the opinion that the court should have been consistent and uphold the local standard of the 11 attorneys general that filed this very historic case.
Okay.
But unlike 2004 and 2006, when emergency rule was challenged in Plateau State and Ekiti State, this time around, the Supreme Court went beyond its previous position by simply saying here, since you have no local standard, the court has no jurisdiction. But the Supreme Court went further, and it's only the Supreme Court that can do that by making policy pronouncement on Section 305 of the Constitution. Thank you.
All right. Well, so what you're saying, because I mean, you were going ahead of me. Let me put it like that. So I wanted you to speak to the issues you're raising already, that the plaintiffs did not demonstrate the existence of an actionable dispute between them and the Federation to warrant the exercise of the court's original jurisdiction. You want to explain that further, what they were trying to say?
Well, the court is trying to say that with respect to the imposition of emergency rule in Rivers State, and the suspension of Governor Fubara and other elected officials in that state. The court was saying that action of the president or the decision of the president on Rivers State do not create a dispute or did not create a dispute between the plaintiffs, that is the 11 attorneys general, and the